Hello and welcome back to my channel. Today we're talking about why funding your trust is a critical step in the estate planning process. Full disclosure, I am a big fan of using revocable trusts in my clients' estate plans. I use them in modest estates and in the estates of the very wealthy and everything in between. I use them for clients who have the so-called traditional family, a spouse, 2 children, and a dog. I use them for single clients who wish to leave all of their assets to favorite charities. Trusts are advantageous and beneficial in a myriad of client situations. And one of the primary reasons I like trusts is the ability to avoid probate. However, simply having a trust is not enough. There are certain steps that must be taken to make sure that the benefits of a trust are maximized for you. So, what are those steps? First, to understand the importance of these steps, a basic definition of what a trust is and what it does may be helpful. Legally, a trust is a separate legal entity created by an agreement between the grantor or settlor and a trustee designed to provide for beneficiaries. In real-life terms, think of your assets, your home, and maybe other real estate that you own, and financial accounts that you have. Currently, you're the owner of those assets, and you control those assets. When you pass away, any assets owned in your name alone, without any beneficiary designation, will require a probate to be transferred to your heirs or beneficiaries. Now, think of your trust as a container that can solve that problem. You can transfer your assets to the container, which is your revocable trust. During your lifetime, you retain full control of that container and the assets within it. You can use and spend the assets as you see fit. Then, after you pass away, the trust, that container, will continue to exist, and your assets will continue to remain in that container. At that point, a successor trustee can step in to manage the distribution of your assets, and no probate will be required. But for this to happen, formalities must be followed and pitfalls must be avoided. The biggest, most major pitfall is failing to transfer your assets to your trust. This transfer of assets is referred to as funding your trust. Now, it's great when you've finally decided on the terms of your trust. Signing the trust agreement is essential. However, if you fail to fund your trust, all of that work has been for nothing. If your assets are not somehow tied to your trust, you've lost the probate avoidance advantage. This is because your assets still belong to you. The ownership has not transferred to that container, which is your trust and which continues on after you pass away. In practical terms, what does funding your trust look like? Let's start with real estate. In many states, including Minnesota, you have the option of transferring ownership of your real estate to your trust now or transferring it after your death. If you wish to transfer it now, you would likely prepare, sign, and record a quitclaim deed or similar real estate transfer document. Many states also offer the non-probate option of a transfer on death deed. This deed has no impact during your lifetime, but if you should still own the real estate covered by that deed at your death, the real estate will transfer to your trust with a very simple filing with the county recorder's office. Now, each state will have slightly different options or requirements for how to title real estate in a trust. Be sure to check and follow the requirements of every state in which you own real estate. Now, let's talk about your non-retirement accounts. By non-retirement, I'm speaking of assets like your bank accounts and brokerage investment accounts. Again, you can either transfer these assets to your trust now, or in most instances, you can sign a payable on death or transfer on death designation form, naming your trust as the beneficiary. Each bank or financial institution will likely have their own forms for you to complete. A side note on retirement accounts, such as employer plans, IRAs. Be sure to work carefully with your lawyer and/or your financial advisor before naming your trust as a beneficiary of any retirement accounts. The administration of these accounts is far more complex than standard investment accounts, and your wishes can often be achieved with proper beneficiary designations naming individuals. This will also avoid probate. For life insurance, I generally recommend naming your trust as the primary or secondary beneficiary, depending on your marital status and the expected financial needs of any surviving spouse or children. Again, contact your insurance company to complete or update a beneficiary designation. If you are a business owner in a corporation, partnership, or LLC, you can generally assign your business interests to your trust through a specific assignment. Note that the governing documents of any business may also control the disposition of your interest at your death. Similarly, for personal property, that is your stuff, a general assignment will make sure that everything falls into the trust. So, what happens after your death if you have not funded your trust? Generally, a probate court proceeding will then be required to transfer the assets to your trust. Another possibility is that old beneficiary designations will remain in effect and assets will not flow as you intend. Practical tip: when working with your attorney, be sure to disclose all of your assets and ask for guidance on how to make sure each asset is properly tied to your trust. Using a revocable trust in an estate plan is often the most efficient and cost-effective way to proceed. But to ensure that this is the case for you, be sure to fund your trust entirely. Thank you for watching today's video. If you have any questions or would like to get started with your own estate planning, please be in touch.